Thank you so much for having me, and thank you to Dean Drumble for that very warm introduction. I just want to give a shout out to Dean Drumble. I know firsthand what it is like to be an interim dean because I served as the interim dean for my law school, Berkeley, where I was before NYU, for about 17 months. And I know it's 17 months and 22 days because I counted all of them. So it is a lot to step up to take on this kind of leadership role in a period of transition. And some people say step up, some people say step into it. I'll let you decide, Dean Drumble, but your leadership during a transition period for your law school, I'm sure, is very much appreciated. So thank you for having me. I am really grateful to the Order of the Coif for selecting me as this year's Distinguished Visitor. This is my first visit to Washington and Lee, I'm sad to say, but it will not be my last, and I'm very grateful for your tremendous hospitality. It's really been a delight to be a part of your community today. And I think it's entirely fitting for me to deliver a lecture today about the intersection of race and reproductive rights here at a university that is named for two men who were pivotal in the history of this country, but who were also well known in their times and beyond as slave owners. To be sure, I am no stranger to the complicated commitments of America's founding fathers. As Dean Drumble said, I attended the University of Virginia as an undergraduate, and one of the many jobs I had to support myself in college included working as a tour guide at Monticello, the home of Thomas Jefferson. And as part of our tour guide training, we were required to read the biographies of Jefferson, as well as his considerable body of correspondence and writings. And then, as a second-year student in college, it was very difficult at times to reconcile the Declaration of Independence, Jefferson's soaring meditation on democratic self-government, with notes on the state of Virginia, in which Jefferson subscribed to and indeed entrenched a notion of biological racism that seeded the eugenics movement that would later take root here in Virginia and would spread throughout the country in the 1920s. I raise all of this to say that I very much appreciate that this university, like my alma mater, has been grappling with the meaning of its history and the legacy of fabled namesakes. As I know too well, history is complicated and imperfect, and all too often it reveals to us the complications and flaws and frailties of those whom we most venerate. Nevertheless, grappling with our history in all of its complexity and nuance seems exactly the sort of thing that a university and its community must do. And I commend you all for the work that you have done and will continue to do on this front. This lecture is of that vein. It is rooted in history, and it is a history that, like that of many universities, including my own, is complicated and often troubling. There's much to say right now about the landscape for reproductive rights and justice in this country, but this lecture does not necessarily focus on the present. Instead, it reflects on the past and uses it as a lens through which we might project our present and perhaps even our future. The lecture is drawn from an article that was published in April in the Harvard Law Review, and it focuses on the dynamics at the Supreme Court and, of course, the question of abortion at the court. As many of you know, the recent changes in the court's composition have left many fearful about the fate of abortion rights. More particularly, many worry that the court will use a case that is currently pending, Dobbs versus Jackson Women's Health Organization, to overrule Roe versus Wade, the landmark 1973 decision that famously recognized the right of a woman in consultation with her physician to choose an abortion. In this paper, I argue that these fears for Roe's longevity are well-founded. But I argue that the threats to Roe go beyond Dobbs and this current term of the Supreme Court, and indeed may not even come from well-worn arguments about the decision's textual fidelity or the workability of the abortion right. Rather, I argue that the emerging threat to abortion and contraception comes from a surprising direction: the ongoing quest for racial justice in the United States. So with that in mind, let me give a roadmap of the talk. First, I want to say a little bit about the origins of this paper, and in particular, I want to highlight a concurrence from Justice Clarence Thomas in a little-known case from 2019, Box versus Planned Parenthood of Indiana and Kentucky. That is the heart of my argument. In doing so, I'm going to focus on what I think are the three principal contributions of the paper and why I think they're important, and I want to discuss, in doing all of that, how the Box concurrence and Justice Thomas's writing in that concurrence may lay a foundation for overruling Roe versus Wade and curtailing reproductive rights, including contraception, on grounds of racial injustice. I also want to talk about the history that Justice Thomas marshals in his concurrence, and I want to say a little bit about my own effort to provide a more complete history and why that elaboration of Justice Thomas's account is both important and necessary. And then finally, I will note that I'm quite confident that the Box concurrence will have important repercussions for the court's reproductive rights jurisprudence, but I also think it is crucial for the court's race jurisprudence as well, so I will say something about that. But with all of that said and those caveats duly issued, let me get right to it and say a little bit about this paper and its genesis. So in May 2019, the Supreme Court issued a per curiam opinion on the shadow docket in a case called Box versus Planned Parenthood of Indiana and Kentucky. This was a challenge to two Indiana abortion restrictions, one of which was a trait selection law or a reason ban that prohibited abortion if intended for purposes of race or sex selection or because of the diagnosis of a fetal anomaly. Although the per curiam opinion granted cert and upheld one of the challenged restrictions, it denied certiorari as to the challenged reason ban. And this prompted Justice Clarence Thomas to write a separate concurring opinion in which he chided the majority for denying cert and basically punting on this question of whether reason bans were permissible exercises of the state's police power. And that might have been the end of things. But Justice Thomas went further. And in this concurrence, he not only chided his colleagues for refusing to take up this question of the constitutionality of reason bans, he crafted an opinion in which he conflated the history of the eugenics movement and the birth control movement in the United States with the history of abortion. As he explained, Margaret Sanger, the founder of what we know today as Planned Parenthood, worked hand in glove with the eugenics movement to spearhead efforts to expand the use of birth control within the Black community, ostensibly for the purpose of targeting and stamping out Black reproduction. And in making this claim, Justice Thomas was no doubt thinking about the disproportionate rates of abortion among Black women today. And perhaps he's viewing these disproportionate rates as the contemporary residue of this earlier effort to market family planning measures to the Black community. But then Justice Thomas circled back to the challenged reason ban, observing that such restrictions were not impermissible because they were merely the state's modest attempt to ensure that abortion did not fulfill, as he put it, its eugenic potential to eliminate unwanted traits or characteristics. When it was announced, the concurrence and the decision itself received some attention, but it was quickly overshadowed by other major developments at the court. But I remained absolutely fascinated by this case, in part because it seemed to touch on so many of the issues that I focus on in my own research, including the changing discourse around abortion in doctrine and in society. And one of the things I've been especially interested in is the way in which the reproductive justice movement has salted the traditional discourse around abortion and access to contraception with concerns about race and class inequality. As reproductive justice advocates have argued, impositions on the abortion right are not simply assaults on women's autonomy and equality. They disproportionately impact women of color and poor women, and as such, should be understood as posing intersectional harms. And it struck me as I read the Box concurrence that Justice Thomas seemed to understand and recognize the way that the reproductive justice movement has helped to shift the debate about abortion and reproductive rights from simply a question of sex equality to one that also engages questions of race and class equality. In this regard, if the reproductive justice movement in tandem with the traditional reproductive rights movement is arguing that abortion is not just about white women, but about poor women and women of color, that is, that restrictions on abortion are not just about gender injustice, but about race and class injustice, then Justice Thomas's concurrence turns this logic on its head by countering that the real racial injustice is not what abortion restrictions do to women of color, but rather what abortion does to communities of color. And the logical inference from this is that abortion can be used as a tool of deracination amongst marginalized communities. Justice Thomas is particularly well positioned to make this kind of intervention. He has always been stalwart and transparent about his objections to the abortion right, but he is also the person on the court who consistently raises questions of race and racial injustice, even in cases where race is not obviously salient. And it occurred to me that this concurrence was not simply a one-off, as some commentators had suggested, but rather Justice Thomas's effort to seed new ground in the abortion debate. So what might this new ground look like? Well, on one level, the Box concurrence bolsters a defense of reason bans that has already been percolating in the lower federal courts. And indeed, the Seventh Circuit, in its disposition of Box, saw Judge Frank Easterbrook dissenting, a dissent which then Judge, now Justice, Amy Coney Barrett joined. And in that dissent, Judge Easterbrook suggested that reason bans might fall outside of the scope of Roe and Casey because those cases had never considered abortion restrictions that were not aimed at promoting women's health, but rather were positioned as fetal anti-discrimination measures. Right, so the understanding here is that these reason bans are protecting the fetus from discrimination, and for that reason are outside of the scope of Roe and Casey. The Box concurrence furnishes additional support for this idea that state-level restrictions on quote-unquote eugenic abortion do function as anti-discrimination measures and thus are outside of Roe and Casey. And to be very clear, the Box concurrence has already been cited for this position, both in amicus briefs filed in challenges to reason bans and among members of the lower federal courts. In January of 2021, in a case called Rutledge, the Eighth Circuit invalidated an Arkansas reason ban that prohibited abortion where there was a Down syndrome diagnosis on the ground that it functioned as a pre-viability ban in violation of Casey. But even as it struck down the law, the majority opinion also noted that the court could, in time, revisit whether Casey applied to reason bans at all. And in a concurrence, Judge Bobby Shepard explicitly cited Justice Thomas's writing in the Box concurrence, noting that Casey's viability standard, quote, does not and cannot contemplate abortions based on an unwanted and immutable characteristic of the unborn child, end quote. The infusion of equal protection rhetoric into the question. More recently, the Sixth Circuit has upheld an Ohio reason ban, and there, the majority opinion and all of the concurrences cited or referenced the Box concurrence and the prospect of what they termed eugenic abortion. So it's clear that the Box concurrence has had immediate implications for challenges to reason bans. But as I read the concurrence and ruminated on it, it became clear to me that the concurrence's import was not limited to the short-term defense of reason bans as anti-discrimination measures. To me, it seemed the concurrence and its effort to change the social meaning of abortion by associating abortion with eugenics and the Black community was perhaps part of a longer-range strategy to destabilize and eventually overrule Roe versus Wade, as well as constitutional protections for contraception. So one of the distinct contributions of this paper is to explain how this could happen. And as I show in the paper, by associating abortion with eugenic racism, the Box concurrence lays a foundation for discrediting and indeed overruling Roe versus Wade on the alleged ground that the abortion right is rooted in and tainted by racial injustice, specifically the eugenic effort to selectively target and impede Black reproduction. The argument is even more forceful for contraception and Griswold versus Connecticut, the 1965 decision that famously announced the right of privacy, which undergirds access to contraception. Margaret Sanger's associations with the eugenics movement irredeemably taints modern-day contraceptive use with the brush of racism, transforming an act of individual autonomy into a racialized assault on minority communities. Now, because of stare decisis, past decisions like Roe versus Wade and Griswold cannot be overruled simply because a majority of the current court disagrees with it. Instead, some special justification is required. Justice Thomas's association of abortion and contraception with eugenics constructs the case that racial injustice is the special justification that warrants overruling Roe. The idea that race and remedying past racial injustices may serve as a special justification for reconsidering past precedents is well established in our constitutional history. In Brown versus Board of Education, for example, the court famously revisited Plessy versus Ferguson, concluding that the earlier court had failed to appreciate the psychological damage of segregation on Black children and noting the changed understanding of public education in our society. Likewise, in Loving versus Virginia, the court overruled Pace versus Alabama, concluding that Pace's equal application theory was both incorrect and misleading in terms of its inattention to Virginia's miscegenation laws, which were undergirded by an interest in maintaining white supremacy. In October term 2019, we saw a similar impulse on the court's docket in a case called Ramos versus Louisiana, which invalidated Louisiana's policy of allowing criminal convictions to proceed from non-unanimous jury verdicts. The question of whether non-unanimous jury verdicts could be consistent with the Sixth Amendment had already been considered in a 1972 case called Apodaca versus Oregon. But the Ramos court nonetheless concluded that because Apodaca was out of step with extant Sixth Amendment jurisprudence, and because the Apodaca court failed to consider the non-unanimous jury rule's origins in a Reconstruction-era effort to entrench white supremacy, the 1972 decision was infirm and could be properly reconsidered and ultimately overruled. The court's disposition of Ramos just 2 terms ago suggests how Roe could similarly be revisited and overruled. For years, those who have opposed abortion have argued that Roe lacks a foundation in constitutional text, was improperly reasoned, and has proven to be unworkable over time. Despite these efforts, though, Roe has survived. But Justice Thomas's racialized critique of abortion furnishes new justifications for reconsidering and overruling this embattled decision. Specifically, it provides new factual circumstances steeped in race and racial animus that may suffice to render Roe, as Ramos put it, the remnant of an abandoned doctrine. To the extent the box concurrence provides a path toward overruling Roe, its logic depends on Justice Thomas's effort to graft the history of Margaret Sanger and the birth control movement and eugenics to abortion itself. But as historians and commentators have noted, the history that Justice Thomas deploys for this purpose is both selective and incomplete. With that in mind, the paper's second distinct contribution is to supplement Justice Thomas's account of the racialized history of reproductive rights discourse. So as I explain in the paper, the idea that the association of race and reproductive rights emerged with Margaret Sanger and the eugenics movement of the 1920s is utterly wrong. The entire history of the regulation of reproduction has been shot through with questions of race since the days of slavery. And indeed, concerns about race shadowed efforts to regulate reproduction after the Civil War, when abortion was criminalized, through the 1920s and into the 1960s, and even after the civil rights movement. To put it simply, race, reproduction have always been inextricably intertwined. As I argue in the paper, the idea that broader access to birth control and abortion are part and parcel of a broader effort to curb Black reproduction and limit the political power of the Black community was first articulated by Pan-Africanists in the 1930s and was reprised by both the Nation of Islam and the Black Panther movement in the 1960s and 1970s. In this regard, Justice Thomas isn't saying something new, but rather is tapping into a vein of discourse that has been in circulation within the Black community for some time. The trouble, of course, is that the view that family planning was part of a racist conspiracy to marginalize and subordinate the Black community was not shared by all within the Black community. Civil rights leaders of the 1960s, including Martin Luther King Jr. and Malcolm X, were supportive of family planning measures on the view that being able to control The size of one's family was an important element in stabilizing the Black community's economic and political fortunes. In making these arguments, Dr. King and Malcolm X were simply echoing the arguments that notables like W.E.B. Du Bois, who worked with Margaret Sanger and the birth control movement in the 1920s to expand the Black community's access to family planning on the ground that it would help stabilize economic fortunes. All of this had been said before and indeed been supported by members of the Black community. And more importantly, Black women in the traditional civil rights movement and in the Black nationalist movement vehemently voiced their objections to what they saw as a masculinist association between abortion, contraception, and racial genocide. So these were women like Shirley Chisholm, Toni Cade Bambara, Angela Davis, and Florence Kennedy, all of whom made clear that if the question was racial genocide, the problem wasn't widening Black women's access to contraception and abortion, but rather problems like state-sponsored sterilization abuse that had persisted from the 1920s through to their period. Also, questions were the injuries that they said were caused by unsafe and illegal abortions, injuries that were borne disproportionately by poor women of color, as well as the challenging circumstances in which Black women were forced to raise their children. In the paper, I provide these accounts of this historical period and these objections to this argument about family planning as genocide, because I think doing so is important for three reasons. First, overruling Roe versus Wade or Griswold on the ground that it is a remnant of a racial injustice depends on a history that Justice Thomas has crafted, a history in which the abortion rights founding moment is not in 1973 with Roe, but rather is in the eugenics movement of the 1920s. But as the paper shows, the history on which Justice Thomas relies is deeply contested, particularly insofar as it conflates the history of the birth control movement with the history of the abortion movement. They are two very different strands of history, related to be sure, but working in very different directions. More importantly, the history confirms that there were voices in the Black community who were distrustful of family planning and associated with government-sponsored genocide. But as importantly, there were also other voices, particularly those of Black women, who welcomed widened access to family planning as a means of improving their own fortunes, as well as the collective fortunes of the Black community. Providing this counter-history arms both reproductive rights advocates and members of the judiciary with a more robust historical account with which to challenge the box concurrence and the effort to reshape abortion doctrine and its social meaning. From a litigation standpoint, this may be especially welcome given the difficulty of verifying facts contained in amicus briefs that are submitted to federal courts. Currently, Justice Thomas's historical account is the only one that is being integrated into anti-abortion amicus briefs in the lower federal courts, and there is no mechanism for contesting the content of those briefs or the veracity of their claims. The history that I provide gives pro-choice advocates a means of challenging this historical narrative, or at least makes it clear to courts that the history is perhaps more complicated than the other briefs suggest. But this counter-history doesn't just serve a doctrinal or litigation function. It also serves a political function. If the box concurrence insists on making Black women unwitting dupes in a eugenic plot, or worse, willing co-conspirators in the deracination of their community, then this counter-history actually surfaces the voices of Black women themselves and makes clear that they understood these claims of racial genocide and that they forcefully contested and rejected them. And that kind of representation is vitally important in the politics of judicial deliberation. As I suggest in the paper, when Justice Thomas speaks on the court about issues of racial justice, he does so with a kind of epistemic authority that comes with being the only African American on the court. Likewise, the addition of Justice Barrett to the court may serve a similar function. When the question of Roe or abortion more generally comes before the court, Justice Barrett will likely be skeptical. But because she is a woman, her skepticism of abortion as a means of promoting women's equality and autonomy will likely be imbued with a kind of epistemic authority that may resonate, if not with her colleagues, then perhaps with facets of the public. In a similar vein, Justice Barrett, who is the mother of 2 Black children and a child with Down syndrome, may also be vested with a particular kind of epistemic authority on the question of whether reason bans function as anti-discrimination measures and are permissible. Given that within the current court, certain views and constituencies will be represented in deliberations on the question of abortion and its intersection with issues of race and inequality, it is worth thinking about what constituencies will go unrepresented. And in this regard, the history that I provide gives voice to the concerns of Black women around these questions at a time when they are, for now at least, unrepresented among members of the court. Finally, the paper argues that the narrative that Justice Thomas puts forth in the Box concurrence is not just devastating to Roe and threatening to Griswold and contraception. It will also have devastating consequences for a wide range of intimate freedoms. If the court accepts Mississippi's invitation to overrule Roe in Dobbs versus Jackson Women's Health Organization, that will surely not be the end of things. It may be the end of abortion, but it will not be the end of further legislation and restrictions. This narrative of reproductive rights originating in racial injustice can be used to fuel calls for fetal personhood. If reason bans are essentially anti-discrimination protections for the fetus, then it must follow that more robust protections, including constitutional protections, should accrue to the fetus as well. Additionally, the narrative of reproductive rights as racial injustices can be deployed to discredit, dismantle, and indeed overrule the right to privacy, threatening access to contraception and possibly even access to assisted reproductive technologies as well. But that's not all. As I argue in the paper, the Box narrative and its logic of abortion as eugenics also has implications for the court's race jurisprudence. And if Justice Thomas has been transparent about his skepticism of abortion, he has been equally transparent about his interest in issues of race. He's weighed in very interesting ways in cases that very obviously implicate questions of race, like Grutter versus Bollinger, the affirmative action case, and Virginia versus Black, a challenge to a cross-burning statute in the state. He's also injected race into dialogues in which it isn't immediately obvious that race is on the table, like in cases involving municipal redevelopment, like Kelo versus City of New London, or gun rights cases like McDonald versus City of Chicago. Accordingly, when I read the Box concurrence, it seemed unfathomable to me that Justice Thomas would go to such great lengths to engage the issue of race without intending for his words to have repercussions in the arena of race jurisprudence as well as reproductive rights. So I'm convinced that this concurrence has implications for race jurisprudence, and I'm not entirely sure what those repercussions might be, but let me sketch a few tentative options here. On the one hand, Justice Thomas's reliance on the disproportionate incidence of abortion among Black women may signal that although some members of the court have been unwilling to see disparate impact evidence as probative of a racial injury, perhaps they might be willing to do so in other circumstances where other commitments are in play. To be clear, though, Justice Thomas anticipates that critique, and he drops a footnote in the Box concurrence to disclaim the prospect of any shift in his disparate impact jurisprudence. But regardless, if the logic of the concurrence is successful in overruling Roe or discrediting it, it will do so at least in part by relying on evidence of disparate impact. And that might suggest that perhaps there is more play in the joints in this area. So a surprisingly optimistic turn. Now let me indulge my natural impulse toward pessimism. The other place where I think this concurrence has implications for race jurisprudence is in our understanding of what constitutes a racial injury. Part of what the concurrence does is to signal that the kind of racial injury for which constitutional redress is available is actually extraordinarily extreme. Not just segregation or prohibitions on interracial marriage, but the kind of egregious evil that we associate with genocide and deracination. Now, to be sure, I don't know what the actual outcome will be for any of this, but I think it is worth more thinking on this. It strikes me that we have overlooked entirely, as we do for much of what Justice Thomas has written, the way in which his writing operates at multiple levels, and the way in which it does so and will have a profound effect on decision-making at the court, and especially in the lower courts for some time. So with all of that in mind, I will stop there. I'm delighted to take your questions. It's such a treat to be here at W&L to present this work to you, and I'm looking forward to the conversation.
Who's going to jump in and ask a question?
Thank you. So my question, I guess, is you see the origins of the justice opinion and Justice Thomas's concurrence as developing from him, or where did this, like, I understand that you said, you know, there are some origins of this that are longer, but why did this happen now? And are there other, like, interests that you think might be promoting this?
Right. So the question is, what are the origins of this? Does it originate with Justice Thomas, this narrative of abortion as eugenic genocide? Does it come from someplace else? And why in this moment is it so salient and it's gotten so much pickup? So as I said, I don't think this is the original workings of Justice Thomas. Justice Thomas apparently actually has done a lot of reading about Black nationalism. There's a really terrific book, a sort of psychological kind of profile of him by a political scientist named Corey Robin called The Enigma of Clarence Thomas, where they talk about his interest in Black nationalism and the Black power movement, but not all aspects of it, just sort of the strain, like Black nationalism has a kind of conservative bent to it in terms of its economic outlook and the idea that the Black community needs to be economically self-sufficient and disciplined. And the author argues that Justice Thomas, that's very much part of his ethos. I think it's entirely possible that this narrative of Black genocide that was circulating in the 1960s in the Black nationalist movement was one that Justice Thomas heard, retained, held onto, perhaps has harbored for many years. That surely is part of it, and it has even longer legs. It goes all the way back to the Pan-Africanist movement in the 1930s. Why is it coming out now? Well, one, I think there's a lot of discussion around these reason bans, and the reason bans essentially prohibit abortion if it's intended for certain reasons. Race selection, which no woman has basically ever gone to a gynecologist and said, like, I'm terminating a pregnancy because the fetus is X or Y. So they're very rarely invoked. They are invoked in situations where there has been a diagnosis of a fetal abnormality or anomaly, so perhaps a fatal illness or something like that. So it is a kind of wedge issue, I think, that is being used to divide the reproductive rights community from the disability rights community, and that's one of the reasons why so many of these laws are proliferating around the country. But the interest, I think, in inserting eugenics is one, because it is incredibly resonant as a kind of trope among disability rights advocates. But it can also be linked to racial justice, further dividing the social justice coalition. And more importantly, at a moment like this one, where we have been reflecting on what it means to remedy past racial injustice, I imagine it is actually quite salient, right? So I think there's sort of a perfect storm going on. We've had the reproductive justice movement insist that our traditional discourse around abortion and contraception has to consider the ways in which marginalized communities access these technologies of reproductive control. So they've changed the social meaning of abortion and contraception to be more amenable to questions of race and class inequality. And then we as a country, I think, are thinking about racial inequality in a more salient way than we ever have. And then you have a justice who sees the composition of his colleagues changing in ways that are a real boon for him. He's been biding his time for this, and I think it all sort of coalesces, like this is the moment. And to be clear, no one else signed on to this concurrence. He was alone in this. There were no other members of the court who signed on to this, but it doesn't matter, because where it counts is that there are judges in the lower federal courts who are parceling this out and making this part of the jurisprudence that will eventually return to the court. Okay, over here.
I want to ask, do you foresee anybody currently on the court now or any additional members to the court later kind of advocating for your larger history behind the eugenics movement?
So do law professors write with the idea that people read their work?
Yeah.
I don't even think my husband has read this, to be very clear. I don't know. Like the justices, I assume, have access to Westlaw. Maybe they have it. Maybe they've read it. I don't know. I've been mostly going around and talking to reproductive rights groups because, one, I have been very concerned that no one is countering this narrative. Like, they are focused on that sort of short-term question, like, is this a fetal anti-discrimination measure and therefore beyond the scope of Roe and Casey? When I'm like, there's a bigger game here. And you have to play both defense but also offense on this larger question. So I've been spending a lot of time talking to advocates about how to challenge the history because they've been leaving the history unchallenged. And it's not to say that the history is wrong. Margaret Sanger did work with the eugenicists, but I don't know that she was necessarily in the eugenics movement and the way that we think about the eugenics movement. There's a lot, her biographer talks about the reason that Margaret Sanger joined with the eugenicists is because the feminists shunned her because she was advocating sexual pleasure for women. And they were like, no, we just want voluntary motherhood. We don't want sexual pleasure. And so the feminists were like, Margaret, you're too much for us. She's like, well, I'm going to hang out with the eugenicists. And it was a way of giving her movement the imprimatur of science at the time. Like, eugenics was a science. So there's the history. It's not to say that Justice Thomas is wrong. It is to say that his history is cherry-picked and incomplete. And there is a bigger, wider narrative that could be told and should be told. And this is all part of it. So no one's reading my work. I just tell people in the reproductive rights movement about it and hope they will insert it into their advocacy. But please feel free to tell judges that you know about this. All right, I saw another question over here.
Thank you so much for coming to W&L Law. And my question is this: so there's a view held by some that because we are such a large country with 50 states, that maybe it's okay or incorrect to have different laws regarding, for example, safe abortion access. And I'm someone who opposes this view, and I think it was said at the very beginning of the conference. So I was going to ask you, what's the strongest argument against such separatist views?
So, I think the strongest argument is we don't allow fundamental rights to be decided on a state-by-state basis, full stop. That's the best argument. It's a harder argument to make if you decide abortion is not a fundamental right? So that's the whole flap around the Dobbs case. The person at the Dobbs oral argument who is most trumpeting that view of getting the court out of it, returning this to the states, was Justice Kavanaugh. And he seemed to paint a kind of rosy picture of state-by-state federalism just working. And each state can decide for itself what it's going to do. And he almost suggested, I think he actually did forthrightly suggest that it would return everything to the pre-Roe status quo. I think that's entirely naive and maybe even specious. I think we're not going to see the pre-Roe world because in the pre-Roe world, there were only 4 states that had liberal access to abortion. There was criminalization throughout the rest of the country. What we will see, I think, are interjurisdictional conflicts about abortion of the sort that we are already seeing emerging now. So consider the law that was proposed, I think enacted in Missouri last week, that would make it unlawful for individuals outside of Missouri to assist people in Missouri in getting abortion, even if the abortion happened outside of Missouri. I think that raises a ton of constitutional questions about the right to travel, the Dormant Commerce Clause, possibly even First Amendment rights on free speech. And in the name of all that is Citizens United, if corporations can make donations as speech, then ostensibly individuals can donate to particular organizations as speech too, including Planned Parenthood. So I think those are the kinds of conflicts we're going to see. He's presenting this as neutrality will settle this conflict over abortion, just stop all the litigation, but it's actually going to animate and catalyze more litigation. We're just going to have different questions. There won't be the end of questions. All right, I saw a hand over here. Yes.
Yeah, so last week we had our largest symposium, and Professor Sheila Natasha talked about her work at
So, yeah, I think first, the question of whether the court will overrule Roe may not necessarily, like, there may be other questions about whether reason bans are permissible on other grounds, but I think it's likely that reason bans will be upheld going forward if Roe is overturned. I think that has real repercussions for anyone seeking to use assisted reproductive technology, because most of these technologies, whether it is IVF or implantation, may actually depend on selective reduction in order to bring healthy pregnancies to term. And if it is an abortion that is prohibited, selective reduction is eliminating one possible fetus in order to allow a successful pregnancy to continue. Like, they implant multiple embryos to see which ones will take. And if more than the desired number take, then some are selectively reduced. So I think that's a real question. It has real implications, I think, for intimate freedoms for those who use assisted reproductive technology. So if you create embryos, cryogenically freeze them, and then you do a Sofia Vergara and you break up with your boyfriend and you want to destroy the embryos and he doesn't, like, I don't know that you have any recourse in that circumstance. So, I mean, there are ways in which all of these questions sort of undergird the deep intimacy of some of these decisions. And maybe that is the point. I mean, like, we are navigating a culture of life and life affirming, but what looks like a good life may differ for different people. And there may be some where, like, yes, I want to use ART. I don't necessarily want to have 5 children. I can't afford 5 children, but I'm not able to carry a pregnancy to term outside of using this technology. And I think it really calls it into question. I think the possibilities for coalition building are really interesting here, because among the groups who are most interested in ART are LGBTQ people, right? And I think they are already perhaps predisposed to the question of preserving reproductive rights, because so much of the gay rights movement and the gains that it has made has been rooted in protections for the right to privacy. Lawrence versus Texas, the expansion of marriage to include same-sex couples in Obergefell. So their fight is inextricably linked to the question of reproductive rights. And if Roe falls and Griswold falls, their rights are similarly imperiled. And so, like, how you form a family is a question here as much as whether or not there is a family to be formed. Right?
If Roe is overruled either at the end of this term or at some other time, apart from maybe federal legislation, what do you see as the most promising way forward in terms of continuing to protect these rights?
I mean, I'm sorry, I don't have it. Like, one, I can answer this question. I think Roe is going to be overturned this term. I don't know if it'll be on grounds of racial justice. I'm sure Justice Thomas will write separately to talk about this. Very confident of that. I think the real question is, like, how does Roe get written, or how does Dobbs get written, right? And that I don't know. It seemed from oral argument there are a couple of different pathways that could be taken. There is the Justice Sotomayor, but what about stare decisis? And then, okay, none of you are listening to me. Okay, so that's over. We don't care so much about stare decisis because we think this decision was wrong, right? Then there's the Chief Justice. Can we maybe just, like, uphold this law but not explicitly overrule Roe? And he seemed to be really sort of, let's do this, guys. And everyone's like, we're good. No one was listening to him, right? But he tried valiantly. Then there was the Justice Kavanaugh. Like, what about neutrality and, like, just getting things back to the 1972 good old days? And then I think this was the really interesting point that no one talked about. Justice Thomas went further. I say this in my con law class all the time. What did Justice Thomas do? Justice Thomas went further. Justice Thomas went further. And he asked a question about a case called Ferguson versus City of Charleston, which is not a case about abortion. It's actually a case about South Carolina's use of child endangerment statutes to prosecute pregnant women for misconduct, like endangering the fetus. And it was a puzzling intervention for a lot of people because it has nothing to do with abortion. And I can only imagine, the only reason I could see for that intervention was a gesture toward the fetal personhood argument, which is the fourth way this could be written. Like, it could be written so that this just returns the question to the states, and all of the states can decide, and we can have interjurisdictional conflict for the next 10 years. Or we could write this in a way that decides the fetus is a person for purposes of the 14th Amendment, which ends this entire debate, right? And I don't know where the court is, and it was hard to tell what the appetite was for that range. I mean, I think we know what the stare decisis argument, there was no appetite for stare decisis, very little appetite for Chief Justice Roberts' compromise. So it's really the neutrality or the personhood. I think if there's a personhood argument, good luck with the Women's Health Protection Act, which is currently pending in the Senate and shows no sign of being enacted. That law would essentially codify the protections of Roe into federal law. Even if it did get enacted, it would surely be challenged on Commerce Clause grounds, possibly even Section 5 of the 14th Amendment grounds, and I don't know that it would survive this court. So there's that. And so that really, I mean, and I'm not an extremist about the court, but I think if the only way you kind of dial it all back is to recalibrate the court, and that's a much harder question of structural reforms that I don't even want to contemplate, or I mean, you can contemplate it. I mean, it's a conversation that people seem like they don't necessarily want to have, but that to me seems like the only way to go back. Like, there's only going forward.
So, if they rule in Dobbs that Roe v. Wade is overturned and that abortion is no longer a fundamental right, do you think that they would uphold the Texas case, the citizen suit enforcement mechanism, because abortion is no longer a fundamental right federally?
Well, I think it certainly complicates. So the question is, what happens to SB 8 in Texas, which has been in play, on the ground and enforced since September, so for 6 months now. The court punted on that, saying that it couldn't address the substance of the legislation because there was no proper defendant. So sort of procedural justiciability punt. No proper defendant here. And I think the question, if the court overrules Dobbs, and this is what I think the Fifth Circuit is anticipating, they've sort of kicked the can down in their disposition of the interceding proceedings on that case. They're anticipating the court's going to overrule Dobbs, which will make the question of whether SB 8 just an entirely different question if a case is ever brought that can be heard, which is a different question entirely. So first we actually have to have someone sued, then we have to be able to sue the person who sued under the law, and then you have a challenge to the merits of it. What is interesting about SB 8 that it's worth noting is 16 months ago, Mississippi's 15-week ban looked like the most extreme thing you could do. Now it's 15 weeks, that's enough time. The Overton window has so shifted that, and having SB 8 out here in the offing while the 15-week ban is pending before the court makes upholding the 15-week ban, which is the Chief Justice's most firm desire, look moderate. When in fact, 16 months ago, we wouldn't have called it a moderate outcome at all. And in fact, upholding the 15-week ban is a de facto overruling of Roe, because the one thing Roe stands for that we can all conclude after Casey is that you cannot prohibit abortion before viability, and a 15-week ban does that. So I don't know what happens to the SB 8 ban. I imagine the question really becomes, if they ever get to the merits of it, is if 15 weeks is okay, is 6 weeks okay? And that's a very different question, and I don't know what the appetite is, but I'm sure we'll go from 15 to 12 to 10, and then, conception. Yeah.
So you already talked about stare decisis, but there has been a lot of talk recently about the validity of the court, especially with overturning precedent. And I was just wondering, what you think overturning Roe would do to the image of the court and how people see it as a valid body, especially if it seems like its opinions and precedent change depending on the political makeup of the court.
So the question is, will overruling Roe in Dobbs, if that's what the court decides to do, will that impair the legitimacy of the court? Well, it should. I don't know if it will, but it should. Because, here's the rub. this case doesn't get taken up unless you have 4 votes to hear it, right? So that means there are at least 4 people who are relatively confident that they can pull a 5th vote, that they're willing to take this on, right? Even though it patently violates existing precedent. So back in 2019, when they granted cert on this, they were already relatively confident that they could sway the Chief Justice, and they were willing to do it, right? Then, of course, the Chief Justice switches sides in June Medical Services versus Russo, and it's not the great liberal move you think it is. He joins the liberals in the June Medical case, but he basically changes the test for abortion restrictions from the benefits and burdens analysis that Whole Women's Health requires to the Casey standard, which is just, is this a substantial obstacle? So much more subjective test. But he says, stare decisis compels my vote here. Right, so then it looks like, oh gosh, why did we take Dobbs? This guy's inconsistent. He's wobbly. He's with the liberals now. Then Justice Ginsburg dies 3 months later after the June Medical case comes out. Suddenly, things are looking up again. And Amy Coney Barrett is seated, very expeditious confirmation hearing. As someone who's watching the confirmation hearings now, I'm like, it was already done by now, but cool. And so now now you have a court that has a 6-3 conservative supermajority. That totally changes the interpersonal dynamics on the court. You no longer have to court the Chief Justice's vote because you don't need him. That's why in oral argument at Dobbs, no one is listening to him. He's the Chief Justice in name only for that argument because he doesn't matter. They don't need him. And so that is partly why I think you saw Mississippi change its tact. 2019, when Mississippi asked for cert, it was like, this is not a big deal. It doesn't require you to do anything big. We just want to find out if a 15-week ban is okay. That's all. You don't have to do anything big. 2021, when they're filing briefs before the court, they're like, we would like you to overrule Roe versus Wade. It was like, this you? Yes, still me. And all that has changed is the composition of the court. So I don't know how you get beyond the fact that the outcomes are wildly different, the advocacy is wildly different and more aggressive without noting the change in the court's composition. And that should be a tip-off to the public that maybe the court isn't always neutral. Maybe there is some political motivation here. And it's not just an abortion. I mean, we may see the beginnings of the dismantling of the administrative state in West Virginia versus EPA. I mean, there are lots of cases where we are going to feel the force of a 6-3 conservative supermajority. That whether it has an impact in the court's legitimacy and how the public views the court, I think, is just a much bigger question. And that kind of depends on the public.
Thank you again for coming. I really enjoyed
Thank you for this shirt.
I wanted to, so I'm definitely not the sharpest knife in the drawer.
Stop that. No, stop that.
I know that a lot of this is by design. I know that, like you were talking about with Justice Thomas's concurrence, that he kind of had been abiding his time and that this was going to specifically influence the federal judiciary, which is not lost on me, was reshaped by the last president. So I feel like, in a sense, that this, like you were talking about earlier, this is all coalescing into a perfect storm. And I feel like abortion gets so much talk and thrown around in the media. I want to know if you could maybe touch on what are the battles that we're not paying attention to.
Sure. So basically, I think this is kind of the coalescing of a larger project. I don't know that progressives have always recognized that the court and the courts, plural, play such a huge role. I was when the Democratic convention happened in 2000. Everyone was talking about, Joe Biden passed the Violence Against Women Act. Joe Biden was there with President Obama for DACA. Joe Biden was doing. No one talked about every one of those things was overruled by a 5-4 decision of the Supreme Court. No one talked about that. Courts have not been part of the progressive agenda. very much been a part of the conservative agenda. And I think one of the things that we're not putting together the pieces, right? You're exactly right. It's a very astute observation. You are the smartest, the sharpest knife in the drawer. We are focused on abortion and not connecting it to voting rights, for example. I mean, that's another place where there's like, burn it all down. It's happening in voting rights too. And no one's understanding the connection. When this court overrules Dobbs, the natural response would be for those who object to the overruling of Roe to go to the ballot box and register their preferences. But you can't do that if new laws have been enacted that basically suppress those who would register their objections. You can't do that if your district has been so gerrymandered that you can't register your objections. When they start passing laws in the wake of overruling Roe at the state level and you object, you won't be able to do anything if your state legislature is so gerrymandered that you can't actually have your preferences heard. So there is a way in which the court, through its other decisions, did not, like applying the political question doctrine to partisan gerrymandering, expanding the scope of states to deal with electoral changes, cutting preclearance. All of that has essentially not only changed the infrastructure of democracy, it has actually insulated the court from any blowback that would come from the things that it is doing in other areas where people might object. And I don't know if that's by design, but if it was by design, then someone is sitting back in their chamber stroking a hairless cat for 2 hours. It's genius. Right. So.
You know,